I want to thank Mike Smoyer and the Digital Government Institute for facilitating my being able to speak at a conference amongst palm trees in San Diego while at the same time presenting here at DGI. I know everyone in the audience today feels just awful about my taking on such hardship duty, so consider it my personal sacrifice for the e-record keeping cause. More seriously, I've been asked to do double duty here by way of these remarks. First, Mike offered me this platform to share some of my thoughts as a lawyer at the National Archives about where we're heading in the e-record keeping and e-discovery space. And second, I get to be the warm-up act in introducing Judge Fasciola, a privilege. I promise to keep my remarks relatively brief and to the point. I'd like to touch on three topics that I care a lot about: electronic archiving, smarter e-discovery collection, and particularly smarter searching of ESI for all access purposes, whether they're e-discovery or investigations or FOIA. Let's talk about electronic archiving first. I've said in the interview with Executive Insight, I was interviewed by DGI, that for my 30 years in government, and it has been 30 years now, I'm only one bad conversation away from retiring, that it's really Groundhog Day every day in the government. We wake up, we come to work, and it's still, for most agencies in government, a paper-based world. We're all highly networked. Email and other forms of electronic records are born digital, but they're not managed digitally, and they're not preserved digitally. And so we need to work on that. And in the email space, ever since Armstrong, there have been regulations for the last 15, 16 years on the books that all of us in the room who are public servants of federal agencies need to print out their email or electronically archive their email in electronic record-keeping systems that are approved by the National Archives. How many people in the room do it? I won't ask for a show of hands. Maybe Mike can do that. The fact is that we all have compliance issues with those regs. And there's been movement, generations of software. There are 5.0 and 5.2 version 3 products out there that have been certified that do electronic record keeping, but the problem with those, as often deployed at agencies, is that they still rely on all of us. Everyone in the room here that I'm speaking to, we all have to be record keepers under this software. And we need to move beyond that. We need to move beyond where we're coming to work and we're spending a lot of transactional time doing record keeping. That's not where the government should be at. A smart government moving forward should be one that employs software that has automated record keeping rules in place. You can put rules and filters and intelligence in the software to basically make decisions for us. We can help the software and train it, but we need to have the software make the decisions for us. That's the world that we should go to. Now, in many agencies, there are electronic archives run by IT shops. But what needs to happen, and what my boss, Gary Stern, the general counsel at NARA, and I have been pushing, and that NARA is behind, is to think seriously about scheduling those electronic repositories and working to have a smart electronic archives. What do I mean by that? Think of a triangle. You can draw a triangle on your napkin or your piece of paper here today, and then draw a line halfway through the triangle. On the top is the senior executive service people, the people with titles in the US government manual, people who are running components or parts of an agency. And to the extent that we can basically draw a line and say, those people create permanent records on email, that's what we should do. We should have an email archive that tags those records as permanent. Everything else under that in the triangle would be presumptively temporary, subject to being made permanent by an opt-in mechanism. Now, there are nuances here, and I'm happy to talk to anybody after the conference and when I'm back in Washington about how you go about implementing this. But it's not enough for your IT shop just to put into place one big bucket of electronic archiving of email without thinking about the records management implications. There's a NARA bulletin on this issued in 2008 on email archiving, and I really urge that people have a conversation within the building about it and have a conversation with us. But it's so important to move beyond us all being record keepers on email and moving to some platform that allows for us to go on with the job, with the missions of our agencies, and solve the email problem once and for all. So that's my first point here today. Secondly, I'm going to be participating at AIM in another week's time at a presentation on March 23rd called Rethinking Custodian-Based EDiscovery in a World of Automation. I'm doing it with Chris May of EDiscovery. And the two of us have this presentation. We've done it at the National Press Club before. It's essentially one where we look at the manual versus automated ways of collecting ESI and asking questions. Either for FOIA or for EDiscovery, ask yourselves this. How, when you get a legal hold in effect, there's a litigation that involves EDiscovery, involves electronically stored information, and there's a legal hold put out, how is that actually executed? How is that implemented at your agency? Do you rely on every individual in a large organization that he or she will manually collect the email and send it someplace, or preserve it idiosyncratically in some folders? How do you know that those people are doing a systematic collection? How do you know that it's a repeatable process that's defensible in court, that is essentially the same process throughout the agency? There are lots of issues with manual collection, and we need to think about employing smarter ways to do collection through both through smarter search methods as well as using the IT personnel to really do this for us and not rely on end users. You can see the consistent theme here, both on email archiving as well as on this point, is that relying on end users is already getting off on the left foot. We've done that for 20 years. There are problematic issues involved. All the issues involved is really, there's this inconsistency, there's metadata spoliation, there's self-interest and bias, there's an absence of legal knowledge on the part of end users, there's a failure of attorney supervision, and there are just burdens and costs involved in having to do it all again if you don't get it right the first time. So my second point here is that we need to think and have a conversation among ourselves about the way we collect ESI within the federal government, not only for EDiscovery, but for FOIA and for other purposes, and I'm happy to talk to people about that. My third point is my favorite subject that people have heard me, is about search. I've been on this grail quest ever since the tobacco litigation, which is still going on, and I'm told it's going to go on for years for those of you who are storing your records at federal record centers. The fact is that the way in which we all search for email and for electronic records generally, relying on keywords, has enormous limitations to it. It's well known in the literature. There's a cottage industry of both research and case law that says that. Judge Fasciola has recognized it in the O'Keefe decision. And really, we need to get beyond naive ways of doing searching for electronic evidence. There are a whole set of articles that are well worth reading in the new issue of the Richmond Journal of Law and Technology. There was a conference on March 3rd, and they'll be published in March. I don't know whether by the date of this conference, but go online. It's an online journal, the Richmond Journal, and I have an article about search in there, and there are other really good articles that talk about this. The trends in the case law are really ones where there's really two paths. One is where the parties are fighting over search terms, and they say, Judge, you're going to have to decide this for us. And some judges roll up their sleeves and then do whatever they do. And there's a whole bunch of cases that show that, that judges are getting involved in the weeds. And then there's Judge Fasciola's approach, as in the U.S. versus O'Keefe case, where he said, this is a very interesting issue, and it's really a complex issue, and really you two, as the people the opposing counsel and the clients and the parties involved, really you guys need to work it out. And need to convince me as a judge that you have worked it out in a satisfactory way. And so the O'Keefe decision points to a path forward where judges are not micromanaging search protocols, but they are proactively encouraging parties to get together and jointly negotiate a solution for how to go search for electronic evidence. And I think that we're going to see that more and more, the expectations that we're going to be part of that as federal agencies, as actors in litigation as well. The other point that I want to make about search is that we all need to learn two words, and everybody should write these down and go Google it. Predictive coding. It's an umbrella term for really an information retrieval concept that has to do with latent semantic indexing, but that's my inner geek talking. The fact is that with coding of a seed set, a sample set of any big universe of ESI, you can get the software to basically replicate the codes. You code 100 documents as relevant, you code 100 as not relevant, and then you let the software find like documents, documents that are a lot like near dupes or that cluster in terms of concepts, like those documents, to either be responsive or not responsive, or privileged or not privileged. There's been tremendous strides in the last couple of years. This has really developed since Judge Fasciola recognized in the disability rights case something called concept searching in 2007 to 2011. In 2011, we are ripe for using this kind of software in all sorts of good ways in government. And so I would encourage a conversation in your agency with CIO types and with techie types who really get into this stuff about clustering algorithms and the kind of software that I'm talking about, to see whether you can basically turbocharge your document review. So I have been interested in search for a long time. I think it's a really important area. All of these areas, I think, really come back to me as being ones where we need to think about the software and use principles of cooperation, as evidenced by the Sedona Conference Cooperation Proclamation, to really work with the other side to get to an efficient result. We are public servants. We serve as a public trust. We owe it to the taxpayers to be agile, to be lean, to comply with Federal Rule Civil Procedure number 1, and to do the best job we can with the tools we have. We owe it to the public to find all responsive, non-privileged records in litigation, and to undertake reasonable searches for responsive, non-exempt records in FOIA requests and responding to requests. We can do all these things through better means, through electronic archiving, through automated collection methods, and using the most up-to-date search software for purposes of getting at the ESI. It's a big challenge in times where there's little money. And we know that there's not going to be enough money spent for these particular efforts. So we all just need to focus our attention and see what kind of bang for the buck we can get with whatever technology platforms we have in-house. Everyone in the room here knows my Rosetta Stone slide. If you've seen me before talk at this conference and others, we need to talk in these languages: lawyers, records managers, and those people who don't speak English, the IT crowd. And we need to gather CIOs and general counsels and records officers in one room and sit them together to discuss, not just once, but on an ongoing basis. And if they can delegate by proxy to deputies, so much the better. But everybody in this room, you have self-selected by being here today. You can be those people who could be the agents of change in your agencies. And so I'm delighted to have been able to make those remarks. I'd be happy to be part of a conversation. I know NARA staff would be happy with respect to e-record keeping to be part of a conversation with your agency. And so let's keep the dialogue up. Now, let me